Calling matter number 1312 of 2017, Bakwena Bamaria versus Grantham Mary and others. The Honorable Chief Justice Platt SC and Deputy Chief Justice Martin presiding.
Good morning, everybody. I'm hearing talking. Is that a cell phone? No. Okay. Thanks for all coming. Who is here for the first respondent? Can you just introduce yourselves for the record?
Morning, Chief Justice.
Yes.
And the court. My name is Expropriation. I'm a senior counsel, and I'm appearing on behalf of our first respondent.
Okay.
With my co-counsel. Okay.
Good morning, Honorable Justices. I am Dina Modise, appearing with Legendo on behalf of the first respondent.
Thank you. The second respondent, who's the counsel? Who's the senior counsel?
Good morning, Chief Justice, Deputy Chief Justice. I am Lerato Koza and I'm appearing on behalf of the second respondent. I will actually be dealing with our heads in its entirety, and then with me is my junior counsel.
Okay.
Good morning, Chief Justice. My name is Kukrano. I am appearing on the second respondent.
Thank you so much. Okay. Do you want to start? First respondents? Go ahead. Give me some other pages. What's going on?
As it is in the court, I would like to make a point in limine. I would like to put it before the court that the facts of this case are fundamentally different from that of Msiza case.
Mm-hmm.
This is to mean that in the Msiza case, there were not any development or any processes to be undertaken to develop the said land.
Mm-hmm.
And to the facts before court, there is a process underway to develop the affected land.
Sorry, I'm just going to put my timer on so that I can see how long you're going.
Okay.
So I'm not watching my phone or anything. Okay.
I will then proceed to my introduction.
Okay.
The matter before court concerns the true determination of the compensation, which is just and equitable. Not just equitable, but then according to the section 25 of the Constitution. Mm-hmm. The summary of the main arguments is basically on the appropriate compensation. The court is to determine what amount would be, if needed be, to compensate the first respondent. The first respondent actually obvious that the actual value of the land has to be valued based on its current process to develop it. The second respondent or the state are actually not agreeing to this. That is why the matter came before court. The Constitution says that if parties to expropriation do not agree to the amount of compensation, court can then determine an amount which is just inequitable. The main submission I would like to make here is that when the court determines an amount which is just inequitable, takes into account certain section in the Constitution, which is section 25, subsection 2 and subsection 3. I will then move to this section. It is a common fact that the matter before this court satisfies those requirements which are in the Constitution. And my first focus would be in section 25, subsection 2 of the Constitution, which says as follows: when there is expropriation, it must be done in terms of the law of general application. The second one says it must be for the public purpose or interest. And the third one is that the amount to be compensated has to be just and equitable. So what is just and equitable justices in terms of this matter has to actually go about equating the interests of those that are affected and the public interest. So this would mean that in order for our first respondent or our client interest to be taken into account, certain factors such as the process which is on its way to develop that said land will have to be taken into account. Section 25 subsection 3 goes further to list 5 factors which the court will have to take into account when arriving at an amount that is just and equitable. The first factor would be as follows: is the current use of property. It is a common fact that the family used the property since the time of acquisition for agricultural purposes. But then when the court determines an amount which is just and equitable, will not only have to focus on the agricultural purposes only. The court will have to also consider or take into account the process which is underway to develop the land. The second factor is the history of acquisition, which basically I would like to focus on our client, the way our client acquired the said land. Our client actually inherited the land from her father. The land was back then acquired, or there was a community which stayed there which was forcefully removed. And then the land became vacant for a period of years, which according to common law means that if a land is vacant for a certain number of years, a person who happens to acquire that land wouldn't have to actually take the responsibilities of those that forcibly removed certain people who stayed there before. Meaning that our client here, who is the first respondent, did not participate in the forceful removal of land to the community of Babonabama.
Sorry, can I just disturb you?
Yes.
How long between the forceful removal and them acquiring the land is the amount of time that needs to be done?
It has been put to me by my client that it was a period of over 100 years.
So they were forcefully removed, and within 100 years later,
Land became vacant.
the land was vacant, and they
Yes.
took over from 1920.
Yes.
Okay, so this was around 1820.
Yes. That was when they acquired the land. So meaning that the period of
100 years was between 1820 and 1920.
yes.
Sorry, Counsel, if I could just also ask you a question in line with my sister's questioning.
Okay.
When the first respondent acquired the land through inheritance, was there a land claim? Did she know of a pending land claim at the time that she inherited the property?
No. There was actually not that. As the court, may I continue?
Yeah, you can. Thank you.
The third requirement is the market value of the property. When the court determines the compensation in terms of this factor, it will then have to consider the actual value of the land at this time. And since here there's a process on its way to actually develop this land, the court would also be bound to take it into account. This is to mean that the actual value of the land, according to the agricultural purposes, it is 940,000. That is the second respondent submission based on the estimation which they are given by the city of Johannesburg valuer. So we submit that this actually fails to take into account the process, because this is the amount solely focused on the agricultural purposes. I would like to put it to court that the process, should it become a success, this land would worth a lot. And our client has actually filed permits waiting for approval for the process, and she even took out a loan and signed herself as a surety. Coming to the fourth factor, the extent of direct state investment and subsidy, this factor does not, at this particular matter, apply. This is because it mainly focuses on if the owner of the land back then, during apartheid, got any assistance from the government, which is government of apartheid, to develop the land. So I would actually skip this factor. And the last factor is the purpose of expropriation. The purpose of expropriation is really important in determining the amount which is just and equitable. The reason is as follows. This is because the Expropriation Act says that the court conferred or having to decide an amount which is just and equitable will have to also take the last factor in the constitution, which is purpose of the expropriation. The purpose here is for the public purpose or interest, meaning that the main aim of restitution is for the public benefit. And then if it's for the public benefit, there should be an equitable balance of those rights of the current owner and the public. And I would like to put it to court that an appropriate amount with this regard to this appropriate section I just quoted in the Constitution would be an amount that takes into account the future purpose or the future developments which it's on its way to commence. In the case of duty advisement of transport, the court was faced with the question of whether Expropriation Act still today finds its existence inconsistent with the Constitution. The court held that yes, the Act does apply.
Sorry, Counsel, just to, can you just take us through to where you make reference to that case in your heads of argument?
It's P8.
Thank you so much. Thank
Yes. The court was faced with the question of whether Expropriation Act finds its existence in today's Constitution. The court held that yes, it does, since the Act does not go inconsistent to the Constitution. The Constitution, as the fundamental law of the country or the supremacy law, would mean that each and every legislation which is there has to comply with it. Then the Act does comply with the Constitution. Coming to the actual formula for compensation, it's quite obvious from the Constitution, interpreting it literally, that it has to be just and equitable. And I would like to refer to the case of Highland residents, which the formula was found, and the court basically said this: the compensation which is just and equitable at that time and manner has to recompense. This means that the party in whose land is to be taken from will have to be paid for the actual loss. And according to our client here, or the matter before this court, this would mean that when the court determines that amount, takes into account the personal circumstances, which one of it would be that this is her only asset. And after becoming a widow, she went back there and stayed. That's when she took over the whole process and thought of investing in this property. That's when she realized that she would need to develop this land to make sure that when she retires, she has something to care for herself and her family. In the case of Langanisweni community, the court accepted and quoted the formula stated in the previous case of Islands, that the compensation must be just and equitable in order to compensate the loss suffered by the person in whose land is taken from. Justices, I would like to submit that if the compensation to be awarded to our client does not take into account one of the factors I just stated above or a while ago, this would not be just and equitable, being that compensation on its natural meaning would mean that we take the land and we actually pay you based on what you have lost. So the main formula for compensation is that it actually pays the person so affected of the loss the person just suffered. Coming to the principle of Pointe Garde, I would say that primarily this principle has two criteria. The first one is that it makes sure, or it is there to make sure that there is no overpaying to the seller. this would mean in its opposite sense that there must not be underpaying, which means that our client will have to be compensated based on the actual use of the land and the process which is on its way, since she has already signed herself as a surety and taken loan, meaning that so soon the development will be starting. In a case supporting this principle, it's a case of Sabin versus the Metropolitan Board of Works. So in this case, the court held that when Parliament gives compulsory powers and provide that compensation shall be made to a person from whom property is taken, that compensation has to cover what the person actually lost. So the appropriate compensation in this sense would include everything, starting from the factors in the Constitution, coming to the process on its way, and also taking the personal circumstances, that this was her only asset. And she thought of investing on this land by doing this development. In my conclusion, I would like to remind the court of important submission I made for determination what is just and equitable compensation. Justices, it is a common fact that the second respondent are willing to pay our client 940,000. That is according to the factor which is only for its current use or the history of its use, which is the agricultural purposes. The Department of Land, which is being the one to compensate, does not take into account the process which is on its way now. So this would mean that if this process becomes a success, this land in a decade or in a period of 10 years would cost $500 million. So I submit to court or put it before court that it primarily focuses on these factors. And the reasons set by the respondent are as follows. The first one is that the current value does not mainly take into account the process as outlined a while ago. The landowners have made significant investments, as said ago, which one of it is the loan and buying the vehicle to actually develop the downtown farm, and the use of land, meaning that it would then change after such development. The prayers are as follows, whereof the respondent prays that the court dismiss the second respondent's submission and grant the following orders: that the amount to be paid to the first respondent be an amount that takes into account the process on its way, and when the court tries to find an amount which is just inequitable, does not only confine itself to the matters that are only pertaining to the land, it also focuses on other circumstances and factors. Alternatively, we pray that the restitution be dismissed and the applicant be granted equitable redress in the form of an amount which the court would find just and appropriate. We further pray that the cost of true counsel be awarded to party scale. Thank you.
Before you sit down,
All right.
you've mentioned in limine that the facts are different. Are you asking for any prayer with regards to the in limine point?
Sorry?
Are you asking any relief from your in limine point? You started by saying you're making an in limine point,
Mhm.
and you're distinguishing the one case from your case, the facts of the one.
Okay, yeah. Actually,
What was there any prayer that you were asking for in relation to that, or did you just want to state that up front?
I just wanted to state that up front, so that when the court confines itself to this matter, it does not rely heavily on the facts of Mr. case, because there was no process underway to develop the land.
And this rezoning, when did it start? Before or after the notice was given?
It was actually before.
Before. How
Yes.
far before? Do we know?
I think it's a period of 2 to 5 years.
And has it been finalized, the rezoning process?
Yes, hence she even took up a loan and signed a SABWiL. We're actually waiting for approval, which is 95% to be granted.
And that's nowhere in your heads, hey? You haven't set out these facts in your heads, is that correct?
Yeah.
You could go to 1.3, which would deal with the summary of your argument, or you could go to 4.1. But I don't seem to see it anywhere, unless I'm mistaken.
I would like to put into court that basically I'm not touching to it since it was part of an oral argument.
Yeah, I know it's an oral argument, but it's not in your heads. It's not written anywhere.
Yeah, but then its founding provisions are in the heads.
I know, but what you've said now is not found in the heads.
Precisely.
Yeah, the 100 years is also not found in the heads, as well as the rezoning started 2 to 5 years prior to the notice. That's also not found in the heads.
Yes.
In line with the recent questioning, you've stated in your oral submissions that if the approval comes through, the property will be worth billions in the future.
Yes.
You'll recall that in the Maziza case, which you've referred to, which is quite a well-known case in these matters, and which you said is distinguishable, that there was an offer. There was an offer to purchase the property of some sorts. And the court in that instance said that this was an offer which might not materialize. Do you not think that it would be grossly unfair of us to grant an award of a minimum of 10 million rand if there's a possibility that the rezoning application doesn't come through? How do we know for certain that the rezoning and the development will come through?
Well, during the consultation with our client, she actually put to us that she has already signed 10 permits out of 15 permits, meaning that there are only 5 permits which are left to be signed. And positively, since majority of the permits became a success, this filing of permits would also become a success.
Because do you also, if I could just ask you, because there's no doubt the second respondent will address this point. I just want to get your input on this because again it's not directly mentioned in your heads.
Okay.
Another point that was raised in Maziza is the fact that when the state has to pay compensation, they're utilizing public funds. So they have limited resources available. Do you not think that a minimum payout of 10 million rand on the premise of potentially a development is a very hefty burden for the state to carry, for taxpayers to pay out?
Well, coming to state on how to pay this, we not really want the amount as a lump sum. The state it would be feasible for the state to pay, even maybe pay installments.
And tell me something. You said you must look at the history of the acquisition.
Yes.
They haven't paid any amount for this property, this family. They didn't buy the property. So they didn't purchase the property. According to your argument,
yeah,
they got it because they were there.
Hence, I'd like to common law.
Yes.
According to common law, if certain period passes and then you happen to be the one to be there on that particular land, you assume ownership.
If you've been there for 100 years.
And then that period actually submitted to the court that it has actually lapsed.
And what I'm asking is they didn't purchase the land. They didn't buy it. Like if you're buying land today, the market price is R1 million, you pay R1 million. You want to sell it in 3 years' time, you sell it for 1.5 million, you make a profit of 500,000. They didn't purchase the land when they bought it in 1920. They just acquired the land for nothing in 1920. Is that correct?
I would like to believe that the father of our client, who is a predecessor, would have maybe paid to the state.
No, sir.
For the land.
I don't want you to likely believe. You're either submitting factually that he paid for it, or factually you don't know. Don't likely believe. That's not where we're going. We're going on facts. Do you know as a fact whether he paid for the property or not?
No, not just.
Okay, that's perfect. Anything else? No? Thank you so
All right,
much.
thank you so much.
If it pleases the court, the council would like to continue, proceed.
Just give me a second. Okay, you may proceed.
During the course of this year, property rights on land was actually at the heart of every debate in South Africa. Being in parliament, being ordinary citizens, being also academics. We cannot also overemphasize the importance of this case in its uniqueness, where the first respondent submits that we should actually move away from the interpretation that is provided for by Section 25, subsection 3, from paragraph A to E, where they say that we should actually take the personal circumstances of the first respondent, those which were alluded in paragraphs 6 and 9 of the compromise. We submit that the correct manner of evaluation starts where we determine that there was an act of expropriation, which already the council has already alluded. I will not actually go into detail because they already alluded and we concede to that. But what I'd like to add is that the term expropriation is quite vague in our law and it's not defined. The court, however, in Haxin defined it as, the Constitutional Court rather, defined it as expropriation as the compulsory acquisition of rights in property by public authority, compulsory, which means by way of law. As already alluded, I will not go into Section 25, subsection 2, because already it has been covered by the first respondent. I will actually start from our heads in paragraph 3, the fourth line from the bottom. What is left for this court now is to determine what is just and equitable compensation for the land that has been expropriated, which Section 25, subsection 2, paragraph B states that once an expropriation has been done, what is left is compensation to be paid out, as the formula is laid out by subsection 3 from paragraph A to E. We submit that in Caesar, the court held that Section 25 of the Constitution gives discretion to the courts where a dispute arises into what is just an equitable amount for the court to determine what is just and equitable. It is therefore our submission that the valuation of property by the city of Johannesburg should be accepted by the court as it was conducted by an expert, as envisaged in the case of City of Johannesburg versus the Valuations Appeals Board of the City of Johannesburg. The fact that the first respondent in paragraph 6 of the compromise has made some investments or surety should not be taken into account by the court, as this would result as a future benefit, not a present benefit to what we are here today for.
And we stop you on that point, because the point that you've raised now is what your learned friend raised in terms of what we actually as a point in limine. He said that the facts of his case, or this particular case, are distinguishable from Aziza. If you can address us on that, how do you agree that the facts of this case are distinguishable?
Yes, my Justice. I do agree, but only on the point that personal circumstances of the owner should be taken into account, and also that a development which has commenced has to be taken into account, but we submit that it's a future benefit, and therefore we cannot have a distinctive qualification of what a future benefit will be.
Are you sorry? I'm getting a bit confused. Are you saying that it's not distinguishable and Mziza stands, or you're saying Mziza in this case doesn't stand and you're not relying on it?
We are actually relying on Mziza in terms of the guidelines that were laid in terms of section 25, subsection 3. But then remember, in Mziza, personal circumstances and the developments of the property were not there, and we concede to that they were not there. But then Mziza laid down the guidelines that it should be the Constitution that lays out what is just and equitable.
Okay.
If it pleases the court. This will only mean that the applicants should claim, the applicants being the community, if we were to take the developments that will happen in future, it will mean that the applicants also should claim that the benefits that were from 1920 when they were expropriated of the land, it was actually it's not in our heads, but it was actually our argument last night with my learned friend that if we would have to take into account a future benefit, would we not also be that we should take into account the historical benefits of the first respondent, because the first respondent has benefited from the land. We therefore submit that if that were to take into account by the court, restitution and land reform will not be possible. An award of this nature will only allow persons to claim benefits that do not exist, but would to a large extent undermine the purpose of land restitution. In S versus Masia, in paragraph 3, the court held that persons cannot be punished for crimes which are non-existent. As this we applied into our case, the future benefit cannot be qualified. It is therefore for these reasons that we submit to the court that the manner of calculating compensation in terms of expropriation should be in terms of section 25, subsection 3, from paragraph A to E. When looking at the market value, the weight that is attached to market value, we submit that yes, over the years, case law stated that market value should be the starting point of determining what is just and equitable. However, the courts did say that it should be a starting point, but then they also emphasized that it does not weigh more than the other factors that are listed in paragraph A to paragraph E, which you submit that the court should take into account. In Caesar, again, the court held that market value is not the basis of determining compensation under section 25, where property was acquired in a compulsory fashion. The court held that the point of departure was just and equitable, that market value was just a consideration, and it should not weigh more than the other factors that are listed in the Constitution. What we propose as a starting point to what to be determined as just and equitable is found in the City of Cape Town versus Hindenburg, where the court held that compensation of expropriation was a constitutional matter by virtue of section 25, and therefore the compensation should be paid in accordance in the Bill of Rights. Nothing else, nothing more. We say that in Detroit, the court stated that it is the Constitution, not legislation or any factor, that provides the principles that are applicable when property is expropriated. This was therefore affirmed by Caesar, where the court where the court held that compensation must be prescribed by the Constitution. Coming to look into the factors of the personal factors of the owner, as I have already alluded. Section 25 requires that the state should not pay more than what is due, as this will have a negative impact on the taxpayer. This is my own emphasis. It is also our submission that the first respondent entered into the contract with the downtown company in a modified fashion, just to increase the amount of compensation.
Are you saying that this new rezoning happened after the notice was given or prior to the notice? As alluded to?
After.
After.
Yes.
You're saying after?
Yes. This is actually in paragraph. Is it paragraph 9? Let me just of the compromise. Yeah, it's paragraph 6 of the compromise. That is after, because this has been going on for years. But then my fellow counsel has extensive knowledge on that. I think he will address it in.
Okay.
Yes.
If you can also just pause there. Your learned friend indicated that the first respondent has really gone out on a limb to actually subdivide this particular property and to rezone it, to basically improve it, to the extent that she has had to take out a loan. She's gotten herself into debt. What are your submissions to us in that regard? Do you not think that it is not just and equitable that we pay her out an amount which is going to leave her basically destitute?
My justice, as I said, the first respondent has entered into this contract in a modified fashion, just to increase the value of expropriation. So we cannot now compensate a modified intention. If it pleases the court, may I continue?
Yes.
We submit that her personal circumstances that are listed in paragraph 9 of the compromise should not, this includes that she doesn't have education and so on and so forth, should not also be taken into account by the court. It's not there in the Constitution, as it was established in the case of Binar versus Minister van Landboom, where the court held that market value is an objective concept that should be determined by looking at the circumstances of the property, not the circumstances of the owner. We further submit that the factors listed in terms of section 25, subsection 3, should be of paramount importance, should only be what the court looks into, as it had in Caesar. Furthermore, in Caesar, the court held that compensation should be just and equitable. My justices, I'm referring to Caesar because we submit that is a ground-breaking case, moving away from the two-step approach which was made in Highlands. Determine what is just and equitable by striking a balance between the interests of private landowners and those of the public. Moving right along to the Point-Gaida rule principle, rather. This principle finds its existence in the case between Point-Gaida, Quorum, Transport. According to this principle, the assessment of the market value of land acquired in expropriation, no regard should be made to any increase or decrease of the land. We therefore submit that if the court would actually take into account the developments that are happening now, which are also subjected to permits, which have not also been signed and so on. It should also take into account the Point-Gaida principle, which says that any increase or decrease of the land should not be taken into account when an expropriation scheme has already commenced.
So, just to stop you there, are we to understand you correctly that the fact that there is a pending rezoning which may or may not come to fruition, we shouldn't even consider that in terms of this particular principle? That's not
Justice rephrase the
sure.
question? Yeah.
The point guard principle, you've just stated that the underlying principle is that you shouldn't be looking at an increase or decrease of the value of the land. Would you, in light of that principle, are you saying that your learned friend is incorrect to submit that the possible rezoning, successful rezoning of the property has any bearing on our consideration in terms of compensation?
Yes, my Justice, thank you for leading me to right direction. It's what we say. We're saying the court should consider this principle just in case it takes into account. Yeah. The point guard principle has been applied and reinstated in several cases as a yardstick to determine what is a fair market value where expropriation scheme may influence the land of the value. The principle finds its way in our law in terms of Section 12, subsection 5, paragraph F of the Expropriation Act. Also in Caesar, the court applied the point guard principle. It held that it is a helpful guide to a fair and objective determination of what market value is, since it precludes the subjectives of price increase or decrease because of the act of expropriation. It was also applied in Kumalo versus Portugal, where the court held that the point guard principle, under this principle, the market value at the time of expropriation must be determined by disregarding any increase or decrease in the market value consequent upon the scheme of expropriation. It means once, just to explain further, it means once a notice of expropriation has been served, just as it has been served with the first respondent, any regard should not be taken into account in increase or decrease of the property. In conclusion, my Justices, we therefore submit that the correct approach of calculating compensation is the one that is established in Caesar. It affirms the supremacy of the Constitution in terms of Section 2, and it moves away from the two-step approach which was established in the case of Highlands. Market value is no longer the starting point. All the factors must be taken into account. In our prayers, we pray for an order rejecting the first respondent request of the amount of 15 million, and alternatively an amount not less than 10 million for compensation. An order accepting the proposed offer by the second respondent, which is 940,000, the cost of the suit, and any further or alternative relief that the court may grant.
Is that it? Yes. Thank you so much.
Thank you, my Justices.
In reply, ma'am.
As it pleases the court, I will first begin by addressing questions posed by my honourable justices. The Chief Justice asked the second respondent what happens if the development is not successful. We, as the first respondent, submit to the court that it ought to take into consideration external factors. Section 25, subsection 3 provides that including factors mentioned related to the factors which ought to be taken into regard, we also need to take into consideration external factors which are relevant to the particular matter at hand. And we submit to this honorable court that we do acknowledge that it is not a known fact if it will actually amount to that amount stipulated, which, if successful, would amount to. However, we submit to this honorable court that Ms. Gratham is actually a widow. She dedicated her time to the downtown farm, and disregarding the fact that she intended to rezone the area, the farm, for purposes of her retirement and to secure her future, would be a grave injustice to her. And a further question was posed with regard to the history of acquisition. My co-counsel alluded to the fact that there was a period of 100 years in which land was unoccupied. We acknowledge the fact that it is not in the heads of argument, and we beg the court's pardon in this regard. However, we submit to this honorable court that it was not the Gratham family who forcibly removed the community. They merely acted on the basis of common law, which states that if land is unoccupied, it may be taken ownership of, and that is how our client acquired the ownership of the land. The second respondent relies on the Masiza case, even when there's a fundamental difference in that there is currently a development taking place with regard to the land being rezoned from agricultural to commercial, and we submit that it is not necessarily relevant to the factors at hand, and we ought to take into regard that when interpreting the Masiza case, we should actually interpret it not only on its grammatical meaning, but let us look at the history, let us look at the context of it, as well as the purpose behind it.
If I can just stop you there, because what comes across in Masiza is this issue of the point guard principle.
Correct.
Now, my understanding of your opponent's submissions to us is that once you get the notice of expropriation, that's the line in the sand. That's the peg in the sand. Anything that happens to the property after that point, whether there's an increase or a decrease in the value of the property, shouldn't be considered. Do you not think that the point guard principle is directly opposite to your case in terms of what you're submitting to us in that regard?
Well, we take into consideration that with regard to the point guard rule principle, rather, it was basically founded on the fact that market value is the starting point. And in our submissions, we submit that when interpreting legislation and common law factors, we ought to first rely on the Constitution. That should be the starting point of interpretation of, external factors such as the point guard rule. With regard to the rezoning of land, in paragraph 5 of the second respondent's submission, I'd like to refer your Honourable Justices to paragraph 5 of the second respondent's
Of the
submission.
heads?
Yes. The second respondents submit that rezoning and developments of the land came into fruition after it was clear that the property would no longer belong to the owner, and then the loans were made in bad faith. It is submitted that this is based on inaccurate information, because as stated in our facts, the rezoning, it is not a known fact when exactly the rezoning took place, whether it took place after it had been known to the owner or before. And we submit that the second respondent is relying on inaccurate information. And we further submit that the loans, it cannot be that the first respondent made the loans in bad faith, because she stood herself up for surety, and this is basically an obligation on her part, and it would be prejudicial to her should she not be compensated duly. We therefore submit that the point guard principle ought to be disregarded, and as it pleases the court, I shall now take my leave.
Thank you. Is anything further? Sorry, before you carry on, sorry. I was just writing what you were saying. They referred us to the case notes. Were you also relying on the case notes?
The ones in our submission?
Yes.
Yes,
Because they referred us to paragraph 9 and paragraph 6 of the case notes.
Yes, I was referring to paragraph 6. It reads, Ms. Gratham avers that this is incorrect. She says that the process for rezoning and developing the process is well underway. And based on just that particular point, it is not known whether it is indeed a fact, because this was merely an averment by the first respondent.
So in other words, if you read paragraph 6 and 9, it's not clear. It doesn't say for certain the date of the notice and the date of the rezoning.
That is correct, Your Justice.
So on these facts, we can't tell which happened first.
That is correct, Your Honor. Justice.
And these are the facts that both parties relied on, is that correct?
That is correct.
So these are the only facts we should look at.
Yes, precisely.
Okay, thank you so much. Yes, sir.
Thank you, my justices. Before I commence with our rebuttal, I'd like to invite the court to the Act, the National Building Regulations and Building Standards Act 103 of 1977. Now, the first respondents have submitted to the court that their permits have not received, they have not received permission to carry on with the rezoning and development. Now, in terms of this act, at section 4, 5, and 8, it lays out the time frame required to receive permission. For building plans, it is 6 weeks. For drawing plans, it is 2 months in terms of the property or the nature of the property. Some would go for 1 month, but this particular property requires only 2 months. And further on, if they are applying for line relaxation, it would extend the time with an additional 3 months. So based on this act, for permission to be granted, they would only need roughly 6 months. So they have not received permission to carry on with the rezoning and development of the farm, which would mean that the investment of 900,000 was within the period of the past 6 or 5 months.
But can you say that as a fact? Because wouldn't it be possible with all departments that there's some lag and there's some delay and then something happens and things get pushed out, that it could very well be that it's been longer than the 6 month time period? Where can you show me definitively that it is within the 6 month period?
Well, I am going in relation to the Act, because in Section 8, it does give the first respondents leave to approach the court where there is a lag in order to fast track the permissions that are needed.
And
this case has been before the court for years, to the detriment of the applicants as per the facts.
Okay, and you're saying that they haven't brought any application to fast track their permission, to say there's been this delay, you're supposed to do it in 6 months, and it's now taken you, as the first counsel had said, 2 to 5 years.
Precisely.
And they haven't done that. If that was the case, they would have pushed for it a lot sooner. Is that what
Precisely.
you say? Is that the only point you want to make
No.
on this issue?
In addition to it being within the last 6 or at worst maybe a year.
But you don't
this-
know that as fact.
Yes.
All we know is that they haven't made any applications.
Yes.
Okay.
That is the
Okay.
submission we put before the court.
Okay.
So besides the interpretation of the legislation, which indicates timeframes, just in line with what we've indicated to your opponent, that if you read paragraph 6 and 9, which is what has been filed with us, that in terms of paragraph 6 and 9, it doesn't make a clear distinction as to exactly when the notice was granted or notice was given and the rezoning was applied for. So do you agree that in terms of what's been filed with us, in terms of paragraph 6 and 9, it's unclear, it's uncertain?
I would say so, my justice.
Okay, you can carry on.
Now, Section 25, subsection 3 deals with public and private interest. The first respondents have put before the court that the personal circumstances of their client must be taken into regard when calculating or when valuating the property in terms of Section 25, subsection 3 at paragraph C. Now, the court in Khumalo versus Potgieter, as we have mentioned in our heads of argument, that was a Supreme Court of Appeal case. They held that when interpreting that section that I've just mentioned, that the point guard rule must be interpreted to be read with it. Now, as my learned colleague has put before the court, in order, in line with the point guard rule, there can be no increase or decrease taken into consideration upon notice of expropriation. So, with what we have submitted in terms of the act that we have just put before the court, although it is not clear when the applications were submitted and whatnot, but we submit that no further steps were taken by the first respondents in making sure that the permits were received at a timely fashion to the benefit, rather, of the applicants. I would like to move on to invite the court to paragraph 4.1 of the heads of argument of the first respondent. The first respondents agree that the land is currently being used for agricultural purposes, and for those purposes the land is valued at 940,000. I would invite the court to 10.3 of the heads of argument.
Yes.
The first respondents submit at paragraph B of 10.3 that the first respondent, or Ms. Grantham rather, intends on submitting the application, that it has not yet been done. This is by their own volition.
Where is this? Paragraph 10.3.
10.3b. It reads as follows.
Yeah.
Second, the landowners have made significant investments in the land by planning to take loans to help ease the process for rezoning of the land.
I'm paying surety for the process too, okay?
It is clear from this that the loans have not commenced. At this point, by their own submissions, they are only planning to take it, and it has not taken effect. I would like to move on to paragraph 5.3 of their heads of argument. There is a quote they have used. It reads as follows. The word compensation, as stated by Southwood, I'll skip the name of the case, has a strong connotation of equality between what is given and what is lost. What has been given to the applicants is the land, and the land is valued at 940,000. So it should be common cause that what is lost to the first respondent is the land, which is also valued at 940,000. So no consideration, in our view, should be taken of the 900,000, which has been invested in the DDC and not in the actual land. We put before the court that the point guard rule, as we have stated, has been incorporated into the Constitution, and paragraph C of section 25 subsection 3 cannot be read while disregarding the point guard rule. Thank you.
Thank you. You may be seated. Okay, so we'll now deliberate on what was presented to us, and we'll let you know when judgment is ready.
No.